Now, any judge that was actually being a judge would begin with the statute, would look to the precedents, would interpret it. They don't even mention the statute. They just say, we don't like this policy, and they're engaged in legislation. You take the Fourth Circuit decision, upholding Maryland's laws on so-called assault weapons and large capacity magazines. The Fourth Circuit used to be the most conservative court in the country. I started my career as a law clerk on the Fourth Circuit, and it was 20 years ago. The Fourth Circuit was tremendous. It was dedicated to protecting our constitutional rights. The Fourth Circuit now, they invented this new test for the Second Amendment, and here's what their test said. The Second Amendment doesn't protect a weapon if it would be useful in a military context. This test isn't just sort of questionable. It isn't just a little bit out there. It is nuts. The Second Amendment was designed explicitly to protect weapons that would be useful in a military context. If we were living back in 1789, your musket would be really useful in a military conflict. If you were called up to service, they said, bring your musket. And indeed, the first Congress passed a law. You want to know the first gun control law in America? First Congress passed a law mandating that all able-bodied men must own a musket. Under the
that's an individual mandate we could live with.
There you go. That's under the Fourth Circuit's test. They say, well, gosh, if it would be useful in a military context, in the Second Amendment, it's not about hunting, it's not about target shooting. It's about protecting your home and your family and your life. So under the Fourth Circuit's test, the only things that are protected are things that are not useful in a military context. So apparently the Second Amendment protects feather dusters. You have a right to have a feather duster. If anyone breaks in, you can make sure they're really clean as they're robbing your house. This is lawless.